Thank you for joining us here on Vital for Colorado Radio. I am your on-air producer and serving as ad hoc host once again in the absence of Peter Moore. My name is Jon Ekstrom. Joining me today, first of all, is Simon Lomax, a fellow member of Vital for Colorado. He is the research fellow. Simon, thanks for joining us.
Oh, always good to join you, Jon.
Absolutely. And our special guest today is Kim Brooch, and you are an attorney at Robinson Waters and Odorcio. And Kim, thank you for joining us.
Thank you for having me.
Absolutely. So today we're going to spend some time talking about the recent decision at the Colorado State Supreme Court regarding the so-called Martinez case. But first, before we get there, we're going to dive into that quite a bit, what the decision means, what the case actually indicated, and then some of the legal strategy that went into that. But first, Kim, let's talk about you a little bit. Since you are new on the show, let's introduce you a little bit. Give us a little bit about your background, what your specialty is, and anything you want us to know.
Sure. I've been in Colorado since I was a sophomore in high school. Is when we moved out here. So I'm a longtime resident, and I went to law school here at the University of Denver. I've been with Robinson Waters and Odorcio since 2001.
Wow, that's nice longevity. What is it about the firm that attracted you and keeps you there?
You know, Robinson Waters and Odorcio is set up as a really collaborative type of law firm, and we really try to appeal to clients who are more middle of the road type businesses, as opposed to like Fortune 500s and that type of thing, but we try to offer service that would match what a Fortune 500 would expect. We have about 36 attorneys, and our firm is pretty much across the board full service. We have a really good mix of transactional and litigation partners in our firm. And we even have a couple of specialty groups practicing in franchise law and domestic relations, and I focus primarily on real estate and airport issues, and I've been doing real estate litigation, which obviously encompasses mineral interests and oil and gas issues, so I've been doing that for a long time.
Wow. Well, that sounds fascinating. When you say airport issues, what kinds of issues arise there that might require your attention?
You know, interestingly, I actually work with Centennial Airport primarily, and it's primarily real estate is what I focus on for them, although I represent the airport authority. A lot of the issues just relate to leasing, to tenants on the airport who function out there and dealing with everyday kind of issues. With
it's a massive commercial real estate hub right around the airport, so that makes total sense.
Yeah, absolutely. Okay, I'm always interested in this as a native and as someone who went to high school here. You said you've been here since your sophomore year of high school. What part of town were you in?
I was in Arvada, and I graduated from Pomona.
Oh, no kidding. Yeah. So I'm Jefferson County as well. I went to Golden, graduated from Golden High School.
There you go.
So, fantastic. All right, well, Robinson Waters and Odorcio, obviously our chairman, also works there, so we have great fondness for them, and it's a pleasure to get to feature some of their work here.
Yeah, it was a really interesting project to get to work on, and it's been a lot of fun really collaborating closely with Peter on this issue, who you were referring to. And it's a great area for our firm in general to focus on, and I think, in general, in my practice area, I was an appellate clerk after law school, which is why I really like appellate law, and I like writing appellate briefs and dealing with those particular issues. I clerked for the 10th Circuit Court of Appeals right after law school.
Wow.
Okay.
Fantastic. Well, let's jump in then to the Martinez case. Simon, can you give us a rundown of the origin of the case without going back too far, because we'll cover that in our second segment, but what did the case seek to do?
Sure.
And what was the decision that was rendered?
Sure. Well, Jon, as you and your listeners are very familiar with, if they've tuned into our show before, there's been a long-standing campaign brought by some national groups in Colorado to single out the oil and gas industry and effectively try to ban it from our state. Not get extra regulations, not improve the way it's developed, but try to ban it.
And when we talk about environmental outcomes, that's an important distinction, because that is the only acceptable outcome for a number of groups, whereas other sort of more mainstream environmental groups will seek measurable outcomes, reductions in methane.
Right.
Or, for instance, the recent COGCC rulemaking that moved oil and gas operations further from school boundaries as opposed to school buildings.
That's right. Yeah, your sort of mainstream environmentalism sees the value in domestic energy production under stringent, regulations that we have here in the United States,
And especially Colorado.
and as opposed to sort of importing those energy sources from other parts of the world where the standards are nowhere near as strong, because that doesn't help the planet at all.
Right.
If it's going to be developed in a less stringent way.
And then transported, which, if we're talking about carbon footprint, if you want to,
Right.
Then if you're transporting it, then you are increasing that once again.
That's right. But some groups just have an ideological objection to any kind of oil and gas development anywhere, and they've really focused on Colorado in the last few years. And the Martinez versus COGCC litigation was really kind of the legal front in a much broader campaign to try to shut the industry down. And so basically what happened is you had these environmental groups found a group of petitioners who petitioned the COGCC, that's the oil and gas regulator in Colorado, to impose an immediate freeze on any kind of permitting for oil and gas,
Right.
Until they could do a rulemaking that would prove to the satisfaction of these anti-oil and gas groups that it would be okay to issue permits. And of course they were never going to allow the COGCC to proceed with that. So the COGCC said that the facts and the law don't support us halting all permitting for oil and gas in Colorado, and then it went into the court system, and eventually the case ended up before the Colorado Supreme Court, and Vital for Colorado felt that this was such an important case that they brought in Kim and Peter to really spearhead a friend of the court petition that really lays out just how much work has been done on Colorado's oil and gas regulations, with heavy involvement from environmental groups to make sure that our regulations are really the most stringent in the country.
Well, and Simon, I want to pause you right here for
Yeah.
a second, just for the benefit of our listeners. Kim, can you explain what a friend of the court brief is, what it does, and what purpose it serves?
Sure. So a friend of the court brief is usually limited primarily to the appellate courts, and it's a nice tool that we have available that sort of allows groups that may have an interest in an issue that's coming up in front of especially the Colorado Supreme Court to at least weigh in from their perspective. And one of the benefits of being able to do an amicus brief is when the commission is doing their briefing, they're really limited to the four corners of the record that was produced in the underlying matter that the COGCC used for rulemaking. And the friend of the court briefs, the amicus briefs, can go slightly outside of that. We're not quite as limited. So to the extent there's some policy issues or some practical considerations that may, have some bearing on how the court would visualize it from a broad perspective, those briefs can point that out.
Okay, so it provides additional useful context. And this friend of the court brief, it cannot just be filed by one side, right? I mean, it can be filed by both sides. Is that accurate?
Absolutely. And in this case, there were numerous friend of the court briefs that were filed.
On both sides?
On both sides.
Right, and including many of the groups that are also doing the campaigning for things like Proposition 112 and other anti-oil and gas initiatives.
Okay, interesting. So this was initially, when it was presented, it obviously went to court and was ruled in favor of the COGCC.
That's right.
And then what happened next?
So it went to the district court level, and the regulators prevailed in that case. It went to the Colorado Court of Appeals, and the Colorado Court of Appeals ruled in favor of the plaintiffs on some points. And that's why it was. That's why the Colorado Oil and Gas Conservation Commission and the State Attorney General's office then appealed that to the state Supreme Court. Okay. And part of it was a concern about the impact on the oil and gas sector, obviously, Because to be clear, the groups that were behind this lawsuit were claiming that they were making all kinds of health and safety claims and basically saying that you could not issue permits and foster the growth of an oil and gas industry and at the same time protect health and safety. And the reason why the COGCC and the AG's office wanted to take this to the Supreme Court was because that would set a terrible precedent, not just for oil and gas, but for all kinds of other industries and other regulatory bodies that have a similar kind of regulatory framework that says you have to both consider the need for this commercial activity and the need to protect public health and safety, and you can do both at the same time.
Right.
And so this week the Supreme Court essentially ruled, yes, the law says that you can do both at the same time, and you need to do both at the same time, as opposed to this sort of all or nothing approach that's being pushed by anti-oil and gas groups.
Right, and I think that's an important distinction because some of the coverage that has been positioned as a result of this ruling is that oil and gas companies no longer have to consider health or safety.
Right.
Right, which is a misnomer. And
Yeah.
the point stands that you can do both, and we would argue that you have had both. And I
Yes.
think the COGCC, which is why they fought this lawsuit, would say that, yes, we have had both, and we can demonstrate that we take this into our consideration.
Well, and I think that the brief that Kim worked on really tells the story of how that has happened for over the course of more than a decade in Colorado oil and gas rulemaking, if I'm not mistaken, Kim.
That's exactly what kind of the focus that Vital for Colorado wanted to take on in the brief that was filed on their behalf. One of the things that we felt needed to be highlighted was the fact that that's exactly what has occurred. As you mentioned earlier, Colorado has some of the strongest regulations in the country. And if you go back through the history, which is what the brief really focused on, and you look at the specific changes and framework overhauls that the statutes have gone through over the last 20 years, you can see that the focus really has been on trying to balance all of those issues. And in fact, a lot of the rulemaking and the statutory changes that have occurred have been to strengthen environmental protections and I think focus more on those considerations for
Right.
Colorado.
Right, and this was a process that really started under Governor Bill Ritter in the mid to late 2000s, and was continued through the Hickenlooper administration. And you see this work reflected in all areas of the oil and gas debate in Colorado. I mean, a good example is that one of the most vocal opponents of Proposition 112 last year, which was a setback ballot measure that was basically written in a way that would have driven the industry out of Colorado altogether. One of the most vocal critics of that measure, opponents of that measure, was Governor Bill Ritter,
Right.
citing exactly the same issues, really, that were brought up in Vital for Colorado's friend of the court brief, saying that we have the toughest regulations of any state in the country, and while it's totally fair to ask if there are ways for those regulations to be improved or even further tightened,
Yeah, evolved, sir.
right. Trying to push measures like this litigation or ballot measures that are really just designed to keep oil and gas in the ground, that's not the Colorado way. That's outside the mainstream.
And what's fascinating to me is, I mean, that was like a 650-word op-ed in the Denver Post, written by Governor Ritter, outlining many of the points that you just articulated. He had no skin in the game to do that, outside of saying, hey, you know what, I live here. I've worked in this industry. I've worked with this industry as governor, and the way that we are going about this is not the way we do things in Colorado.
Yeah, and look, I would sort of take that even a step further, John. And since leaving office, Governor Ritter has become a real national leader on energy and environmental policy. He leads something called the Center for the New Energy Economy up at Colorado State University, your alma mater.
My alma mater, very proud of that.
Yep. And so he's focused on the transition from traditional or conventional energy sources to renewables like solar and wind and energy storage and things like that. And I mean, he's dealing with, the reality of that transition and how all these different energy sources are working together, and they're all needed, at different moments, at different times, depending on
Right.
what energy demands are. And one of the things that he's been very vocal about is the role of natural gas, a lot of which is produced here in Colorado, in being part of that energy transition, and how that it reduces emissions, and how it also supports the growth of renewables on the power grid. So there's a difference between approaching these issues sort of in a factual way or a pragmatic way versus an ideological way.
Right.
And the Martinez versus COGCC case, I think, really brought those two perspectives, head to head, sort of this sort of pragmatic, factual, evidence-based approach versus an ideological approach that said, look, we just got to freeze permitting until you can convince us being the anti-oil and gas groups, that it's okay to produce oil and gas.
Right. The latter approach is a real frying pan to the face.
Mm-hmm.
So two questions here. One, Kim, how does your expertise play into this? What did you bring to the table that enhanced the brief that Vital wrote? That'll be my first question. I'll hold on the second one.
Okay. I think just obviously from a legal perspective, taking the factual historical information that Vital and Simon provided and putting that in a package that would be recognized by the Supreme Court and that they would be able to review and rely upon.
Sure.
So it's really just about getting it structured properly, tying it into the issues that the court had granted cert on, so that it was an appropriate use of the amicus brief process. And I think we were pretty successful in doing that.
Yeah, I would agree. Secondly, this is a question for either of you. Why is this called the Martinez case?
Oh, because the lead plaintiff in the case, his last name is Martinez, actually, I'm really glad you brought that up, because something that's been lost in the shuffle in the coverage of this case, not just this week, but frankly the past 5-6 years,
Over the life of it, certainly.
right, is that when he was interviewed on the day that the petition was filed before the COGCC and asked, what is this case about, Chutezcat Martinez, the lead plaintiff, said, I think we've got a really good chance of getting a statewide moratorium or a statewide ban on fracking. That was a TV interview. And so
that's
right
out
from
there for people to hear and to find.
Right from the very beginning, the idea that this was really just another front in the campaign to kind of ban fracking in Colorado, it was clear as day.
Right.
But, the groups ever since then have been trying to sort of dress it up in all this other kind of rhetoric about, well, we're really just interested in health and safety or common sense regulation. But when you actually peel back just a couple of layers, you see it's the same players with the same agenda all along.
Right. Kim, were you surprised when the appeals court ruled in the way that they did? After district court found in favor of COGCC, and then it moved on to the appeals court, were you surprised at what they found?
Yeah, I thought the decision was interesting. I definitely, when I was reading it, I agreed more with the points that the dissent, because obviously it was a 2-1 decision, so it was a split decision. It was not unanimous at the Court of Appeals. They focused on trying to interpret the statutory wording that was in the statutes and how that should be interpreted. And I felt it was a bit of a stretch, the way that it came across in the opinion. And obviously now reading the Supreme Court's version of that, I think it's a much more balanced and reasoned way of looking at the statute. And I think it was appropriate for them to go back and do the legislative history review that they did to try to put some context into the language that's actually contained in the statute. And so, the Court of Appeals opinion, based on what they were looking at, I see where they came from. But when the Supreme Court kind of expanded that review and went back and really did a little bit more review of the specific legislative history, I think ultimately it came out the way it should have.
Yeah.
Well, and I think when you read the dissent opinion at the Court of Appeals level, how much did that, I've seen that, and the wording is very strong and very clear. How much do you think that influenced the decision of the Supreme Court, if any?
I think the one thing that they pointed out when they were writing the Colorado Supreme Court opinion was the fact that when you had the 2-1 decision in the Court of Appeals and you had a dissent and both of them could not agree on the language, it supported at least a finding by the Colorado Supreme Court that the language was ambiguous, and that in turn led them to do the legislative history review that they did. So I'm not sure it really influenced them because obviously they were taking a fresh look at this, but it certainly at least supported the fact that they needed to really go back and do this extensive review to make sure that they got it right.
Yeah, I think one of the things about the Supreme Court's decision, its ruling, and I would also say this about Kim's amicus brief or friend of the court brief is that. When you take a much broader sort of factual view, when you look at the legislative history, you look at how the laws have actually been applied and how they were drafted in the first place, and the regulations that were issued sort of underneath those statutory provisions, it becomes a lot clearer just how Colorado's regulatory framework kind of stands head and shoulders above so many others. And I was reviewing some of Kim's friend of the court brief or rereading it this morning, and one section that I think really we should share with your listeners, John, is what environmental groups themselves had said through this long, more than a decade period of rulemaking and regulating of oil and gas. And I'm just diving in here. It says that, in official statements and testimony, environmental organizations have described Colorado's approach to oil and gas regulation as a model for the nation, setting the pace for the rest of the country, at the forefront of balancing the interests of development with common sense protection for our communities, and among the most progressive and comprehensive in the nation. So, when I think, during that, Court of Appeals period, and the scope of the sort of the inquiry was not anywhere near as broad as what you get when you end up going before the Colorado Supreme Court, especially when there's a split decision at the Court of Appeals level. And it's really, to me, quite striking when you see these environmental groups that were at the table and helping draft these regulations and these laws through the years, and what they were saying about them as they were being written, versus the kinds of claims that you hear in the heat of this, kind of continuing statewide campaign run by, a few organizations backed by out-of-state groups. It's just such a disconnect between what's actually been going on versus what the talking points say.
Well, quickly, we don't have a lot of time left in this segment, but you mentioned a few out-of-state groups. Mm-hmm. And, you mentioned Martinez as the lead plaintiff. Mm-hmm. He's part of a group called Wild Earth Guardians. Tell me a little bit about some of these out-of-state groups, or, for instance, Wild Earth Guardians, what should we know about them?
Well, sure. So the plaintiffs that were assembled for this case were a group of teenagers, and I think that was done in part because they present a pretty sympathetic case on the for the lawsuit. But if you actually look at the lawyers behind the lawsuit, the people who are actually running the case, you end up with a group called Our Children's Trust, which is based in Oregon, which partners with the Sierra Club and Greenpeace, which are two big keep it in the ground groups. And those two groups have been very active in anti-oil and gas campaigning, and especially ballot measures here in Colorado the past couple of election cycles. And when you sort of take a broader look at the campaigns that we've seen at the local and state level here in Colorado, you end up looking at groups like 350.org in New York City and Food and Water Watch in Washington, D.C. And they're a constant feature. They have local organizers here. They have local chapters here, and they're trying to change Colorado policy the way they want, but the agenda that they're pushing is a national policy.
Right.
It's a national agenda, not one that is in the best interest of the state.
And it's not terribly conducive to the way we do business here.
It's very different.
Coming up here in our next segment, we're going to talk a little bit more about the history of some of these organizations, some of the history of activism that has led to this, and this playbook that seems to repeat itself over and over again. If you're interested in hearing this episode, go to vitalforcolorado.com under the Learn tab, videos and podcasts. You'll find this episode and every other one that we have. We'll be coming back here with more in our next segment with Simon Lomax and Kim Brooch. Stay with us. Thank you for staying with us here on Vital for Colorado Radio. I'm your on-air producer and serving as fill-in host today, Jon Ekstrom. I'm joined by Simon Lomax, research fellow for Vital for Colorado, as well as Kim Brooch, an attorney at Robinson Waters and Odorcio. We've been spending some time today talking about the Martinez case and the recent ruling that found in favor of the COGCC at the Colorado State Supreme Court. And Kim, while we were on break, you mentioned something that I thought was interesting, and that is that the COGCC is required to do a balancing test when they issue permits, and that after this ruling, they have to go back and do that. Can you explain that in more detail?
Yeah, I think one of the important takeaways from this case is really to look at what the impact of this decision is. Some of the comments that have been made about the ruling is that, we're really deferring to the oil and gas industry, or they now have, kind of unlimited power, that kind of thing. And I think that's really a misstatement of what the actual facts are. Prior to the Martinez case coming forward, and as is kind of outlined both in our amicus brief and in the opinion of the Colorado Supreme Court, the COGCC is required to balance the rights of the landowners and the producers and the owners of the mineral rights with health, safety, and welfare considerations. It's the statutory framework that they have to operate under. And the Martinez case has not changed that. Essentially, what they did is they just approved the COGCC's decision in refusing to make the rule that they were seeking that would have essentially put a moratorium on any new permits. So you're back now to the status quo, which is any additional work the COGCC does in considering new permits, new drilling, rulemaking, etc., goes back to that same statutory framework, which has not been modified and contains that same balancing requirement.
Oh, that's interesting. Okay. So the balancing test, Simon, is when a company wants to apply to drill a well, there are a number of boxes that they have to check, and I think you've written about this in some level of what's the word I'm looking for here? Detail.
Detail. Okay.
Right. That's a simple word. I could not pull it. You've written about this in some level of detail, but what are some of the things that go into that balancing test? And Kim, feel free to jump in as well.
Sure.
Well, I think one thing that I think you need to kind of look at is, the language of, the mission of the COGCC and the legislative declaration. And, I think, if I'm not mistaken, Kim, any kind of decisions they make about developing energy resources have to be done in a manner consistent with protecting the public health, safety, and welfare and environmental issues
Exactly.
as well.
That's exactly the statutory language.
Right. And so, what the activist groups are trying to say is that by issuing this permit, it's actually inconsistent, right? You're doing this inconsistently, and what the Supreme Court actually found was, no, this COGCC has been issuing permits in a manner consistent. And I think, rather than focus sort of on the details of individual permit applications, I think it's useful to look at, how the COGCC was actually restructured by the Ritter administration and then actually by the state legislature through this whole sort of reform process that Kim detailed so expertly in the amicus brief. And one of the things that they did was that they, a long time ago in Colorado, you actually had a COGCC that was, had a majority representation of people with a background in the oil and gas industry.
Right.
And that's no longer true and hasn't been true for years.
And there were fewer overall commissioners too, right?
That's right. So what they did was they expanded the commission and they brought in the head of the Colorado Department of Public Health and Environment, and they brought in the head of the Colorado Department of Parks and Wildlife. And what that did was to make sure that these environmental concerns and public health and safety concerns were front and center and represented in every single action taken by the COGCC. And this even came up last year in the gubernatorial race, where Lieutenant Governor Donna Lynn, who was in the Hickenlooper administration and had a long career in the healthcare industry before going into public service, and she even has a doctoral degree from Columbia University in public health, and now that she's no longer a statewide elected official, she's now gone back to work for Columbia University's medical system. So she knows her stuff when it comes to health and safety, and she was very, very, very outspoken about how the public health and environmental issues, the health and safety issues that were being talked about by the anti-oil and gas groups, sort of in a kind of political way. She was very clear that the number one concern of the Hickenlooper administration in all of its energy policy decisions, including oil and gas, was public health and safety, and that wasn't just a policy sort of preference from the Hickenlooper administration. It was what was required of them under the framework of laws that govern the energy sector in Colorado. So it really, again, there's a difference between the way a court decision can be covered in the press, and when a reporter will take all of the things that are said in reaction to a court case,
right,
versus actually reading the court case and
right,
reading some of the briefs that were filed on either side and getting a real sense of what the court was actually saying, as opposed to covering what people are saying about what the court
right,
ruled.
Which is really unglamorous work too, and speaks to the current media landscape in which we exist.
Well, and look, in fairness, I'm an ex-reporter, so I'm very sympathetic to.
I think I've heard you say recovering reporter.
Yes, exactly. This decision was released in the middle of a legislative session. There's a political dynamic going on, and so absolutely, the views of elected officials about what the court said, that's news. That should be covered 100%. But unfortunately, I think lost in the shuffle was sort of what the actual standard as outlined by the Colorado Supreme Court is with regard to how you issue permits, and make sure that everything, all the relevant laws are being enforced and applied, but at the same time also protecting health and the environment.
Kim, does that disconnect ever frustrate you? Because you examine this in great detail, as you prepare this brief and you look at the history, and you have to understand the rule as it's written and as it's applied. Seeing that disconnect between the reality and then the way it's talked about, does that frustrate you?
It does, but you also, I recognize as a lawyer that, law is really, what I think going to law school is really learning how to read another language. And I think that it's hard for a lot of people that haven't spent that time and aren't around it all the time to really dig into a case where it's statutory interpretation and get a good feel for what's really going on there.
And it's what people want to spend their time sort of understanding with a great deal of depth, right?
Right. So that's why I think it's important to as we did a few minutes ago, to really focus on, what is the end result. And what people need to understand is that the COGCC is required to do the balancing that is under the statute. That has not changed. And Colorado's statute requires a balance, as Simon was detailing, among owners versus environmental and health and welfare concerns. And that is going to continue. That's going to continue to be the focus, and any permits that are issued are done within that framework.
Yeah, and I think there's also, in the news business, John, there is always, reporters, editors, outlets, they'll always gravitate towards conflict, right?
Certainly.
It's one of the core news values you get taught about when you're at J school. And that's important. When people disagree, that's often newsworthy. But, sometimes we kind of get, obsessed with conflict, or we get focused solely on conflict. That's all we look at. And for all of the talk about conflicting viewpoints that get brought before the COGCC, while this was all happening, when the Supreme Court was getting ready to put out its decision, there was also a tremendous example of collaboration and cooperation that went on through the COGCC. It happened because the COGCC brought people together,
right.
And that was, the change in the setback rules as regards to, drilling in proximity towards schools, like that setback distance. There was a concern that it should be applied not from school buildings but from school property lines, and you saw what the COGCC called an epic collaboration, where
right.
all of these different parties who usually disagree about oil and gas regulation, industry, environmental groups, some school districts and local
right.
governments all came together at the end of last year and agreed that the effective setback should be larger by applying it from the property line as opposed to the school building. So that's just an example, I think, of how it is possible for an agency like the COGCC more often than not to actually bring parties together and find a resolution that works for everybody. But because there isn't always a lot of conflict with that, it doesn't always get as much attention.
Right.
And to be fair, the school rulemaking that was covered extensively. But there are lots of examples like that.
Certainly.
Permit by permit, community by community that get lost in the shuffle because there isn't conflict.
Well, and one of the things that we don't talk about anymore are, you never hear about the planes that land, right?
Mm-hmm.
And in the past, things like chemical disclosure, you don't so much hear about that anymore.
Right.
Adjacent landowner notification, that was a COGCC rulemaking
Right.
that got almost no coverage,
Right.
where you have to notify adjacent landowners if you plan to drill on the property that's near them.
Right.
That was a very hot issue for a long time. It was very quietly resolved.
Right.
Again, you don't hear about that quite as much as you used to.
Right.
Kim, I think I cut you off.
No, that's okay. I was just going to say, and if you just look at the opinion of the Colorado Supreme Court, they point out that one of the reasons that the COGCC did not engage in the requested rulemaking was because they were already working on a lot of these issues with the Colorado Department of Public Health and Environment. Mm-hmm. And so there's a recognition in the opinion as well that a lot of the concerns regarding environment and public safety, health, and welfare, there were active discussions and collaborations happening at the time that this rulemaking was rejected. And so it wasn't being ignored. It was happening. It was just happening on a different front and under a different framework than what they were requesting.
Right. And so to Kim's point, if you sort of looked at the Martinez versus COGCC litigation in isolation, if you looked at the talking points of the activist groups in isolation, you would think that the COGCC is kind of the only body that makes any decisions about oil and gas anywhere in Colorado, when in fact the CDPHE, for example, was and continues to actively address almost everything that the activists bring up as it relates to health and safety, because that's what the CDPHE is there to do. And in addition to being part of the COGCC, they have their own rulemaking, their own authority, their own laws to enforce, and they do. And then there's just the sort of interlocking or overlapping layers of different state, federal, and local regulation that apply to oil and gas that make it such a heavily regulated industry that, when activist groups choose to focus solely on a single state agency like the COGCC, I can't help but think that is in part meant to try to minimize everything else all these other agencies do to address the very concerns that the activist groups say they care about.
Right. And what's interesting to me is everything that you've just articulated would seem to indicate that people should have a high degree of comfort with the level of regulation occurring over this industry in this state. Yet, you go back in the history, and Simon, you and I have worked on this pretty extensively over the last few years. Going back to 2012, Longmont, by ballot measure, passed a full fracking ban within city limits.
Right.
In 2013, 4 municipalities passed either bans or moratoria, right? And that was Boulder, Lafayette, Broomfield, and Fort Collins. And one was eventually defeated in Loveland, I believe.
That's right.
Although it was before the people. From there, those bans get enacted, they go to court, they end up failing because they are unconstitutional, because the COGCC has authority, and I think we've spent a lot of time here talking about why they have authority and the balancing test that they have to enact. Yet this playbook persists, and you look at this Martinez case, why does this keep happening?
I think, well, there are a lot of reasons for it, John, but I think, first of all, Colorado is a leader both in energy production and in environmental regulation. So you remember that I mentioned earlier about sort of the leading role, toughest in the nation, assessment of Colorado's oil and gas regulations, and that's just oil and gas. The things that we do in the electricity sector are also held up as an example for other states. But we're also the fifth largest producer of oil in the country, and the sixth largest natural gas producer in the state, and what that in the country, and so what that means is, Colorado, if you're an anti-oil and gas group, a major energy producing state is a target of yours, and so Colorado has been targeted by these groups since at least 2012, and the ideology of these groups is that literally on their website it's ban fracking everywhere, or keep oil and gas in the ground. Like, there's no level of regulation that would satisfy them that oil and gas could be produced in safely and environmentally responsible manner. And really it comes down to sort of an ideological objection to oil and gas. And so the role they have played in these local battles really has been to come in and, instead of allowing Colorado's kind of regulatory framework and local officials and state regulators and oil and gas operators and other interests.
All concerned stakeholders.
All concerned stakeholders, all with very legitimate interests and questions about how energy should be produced in Colorado. Instead of allowing the system to go to work and bring people together and find ways, if possible, to resolve any conflicts that may exist. These groups are expert at running political campaigns that come in and exacerbate the conflict, make the conflict worse. Because if they can drive a narrative that's filled with conflict and controversy and fear, then that's the kind of thing that can quickly be spun up into, instead of a local campaign, a statewide campaign. Right. And that's exactly the kind of thing that we saw last year with Proposition 112, and we saw them propose similar measures in the 2014 and 2016 election cycles as well.
And let's call a spade a shovel here, right? If we're quoting Arrested Development, there's always money in the banana stand. Am I right?
Yeah. I mean, look, these groups exist to do one thing, and that's to run campaigns against the oil and gas industry. That's what they're set up to do, as opposed to the oil and gas industry or any other sector of the economy, for that matter, that actually have a purpose, have a product, have a day job essentially to do. And so they get dragged into these legal fights and political fights and legislative fights, and they have every right to to participate and petition the government and try to defend themselves. But it's not what they exist to do.
Right.
And so, I think one of the challenges that policymakers in Colorado have faced and will continue to face is when groups like these come in and make a series of demands, make a set of demands, experience shows that even if you meet those demands, then all of a sudden you're just presented with a new set of demands.
Right.
Because the campaign must always go on. Unless and until Colorado is going to actually impose an all-out, flat-out ban on oil and gas development. And there's just no support for that in Colorado.
Right.
And that's why you end up seeing these campaigns always kind of cloaking themselves in different kind of talking points than a ban, like setbacks or health and safety and things like that. The objective hasn't changed at all, but they understand that if they were, straightforward about their objective with voters, there's not a chance in the world. There's not a chance in the world the voters would support that.
So, okay, given that these failures keep happening, I mean, with some limited success, the moratorium in Boulder County seems to have no end in sight and just continues to get renewed. Where do they go from here? I mean, repeatedly, this has been struck down. This has been either rejected at the ballot box, as Proposition 112 was in 2018. They didn't get enough signatures in 2016. It was pulled at the last minute in favor of a Blue Ribbon Task Force in 2014. And then we've talked about the series of legal defeats, whether that's the Longmont fracking ban of 2012, Fort Collins in 2013, or the recent Martinez case. What happens now?
Well, I mean, they have been very clear and have spoken very publicly about two things. First, they're trying to exert whatever influence they possibly can over the state legislature and the newly elected governor, Jared Polis. And they've issued a list of demands that these are the groups behind Proposition 112, which was defeated by a wide margin last year.
And the way you say that, they've issued a list of demands, that sounds very sinister.
Well, it is... I don't know about sinister, but it's really quite astonishing, John, because, Proposition 112 was a half-mile setback from occupied buildings and a host of geographical features all across the state that basically meant that it was a 2,500-foot setback from just about everywhere. And that was rejected by voters. And the list of demands that these groups have brought to the legislature, and a list of demands, they say, if it isn't met, they're going to bring back another ballot measure in 2020. That list of demands goes further than the ballot measure, way further than the ballot measure.
Interesting
that was defeated, right. Which, by the way, contrasts very strongly with what the oil and gas industry's approach has been. And even though the oil and gas industry defeated Proposition 112 on election night, starting from election night, the oil and gas industry has done nothing but signal its openness to discussions about, good faith efforts to improve regulation in Colorado if some common ground can be found. I'd really it remains to be seen whether or not they actually do exert that influence, but. You know what's really interesting to me, and this is kind of like the connection with the Martinez case, Kim, is that one of their principal demands is, guess what, a statewide moratorium on issuing permits until they can until the COGCC can pass whatever test the anti-oil and gas groups set for the COGCC.
Right, and we've already heard that there's some draft legislation in the works. I mean I haven't seen any of it yet, but certainly there's going to be some things proposed. And I think one of the issues that'll come up if they approach this from trying to change the statutory framework is obviously then you're going to get a focus on private property rights.
Right.
At some point these things also have to be balanced in terms of a property owner's right to gain value from his property and use it how they want. And, the way that the framework is now, you can certainly put regulations on that, and it's legitimate to consider these health and safety welfares. But if legislation goes too far and results in some of these bans or moratoriums that are really going to start causing diminution in value to property rights, that's probably going to be one of the next battles.
Right.
Well, and I think that's a look into the future in terms of where we go from here legally.
Yeah.
Fair to say?
I think so. I mean, I really think that if the legislative framework is the way that they try to go next, that's probably one of the big next court battles. Is you're going to have to see where that comes out with property rights in general, and whether those are takings, and whether you can really impart legislation that removes a valuable property right in its entirety.
Well, and just to be clear, just because these groups are seeking to influence the legislature and the Polis administration doesn't mean that they will succeed. I mean, they sought to influence the Hickenlooper administration, and they didn't get very far there.
No, there was, and I mean, if we're talking pragmatically, there was some success there in terms of the number of rulemakings that happened. But again, we're not really interested in that.
Well, exactly. And look, the public statements from Governor Polis and legislative leaders, that we have seen so far, have all said, yes, we want to, look at the way oil and gas is regulated and make some changes. But they have also gone to great lengths to point out that they're not interested in trying to put the oil and gas industry out of business in the way that anti-fracking groups want to.
Absolutely.
And it'll all depend on, what the detail of what's proposed and all of that kind of thing. So we'll just have to wait and see. But I just wanted to stress that just because these groups
Right.
are telling the legislature that they want these things doesn't mean they're going to get
A
them.
fair point and a good caveat.
And our legislators understand that you have to balance the economic concerns with the environmental concerns with the property right concerns. So it would be surprising if you got something that was that extreme.
Absolutely. And we're only in January, so a lot remains to be seen. So,
That's right.
Kim Brooch, real pleasure having you here.
Thanks so much.
You can find her at Robinson Waters and Odorcio. That's rwolaw.com. You can find Simon, myself, and the rest of Vital for Colorado at vitalforcolorado, all spelled out, .com. Go to the Learn tab under videos and podcasts. You'll find this episode and the other 70-plus episodes in our archive with thought leaders from all across Denver and some from across the country. Thank you for staying with us. Have a great day.